Welcome everyone. I'm Mary Brown Sands, Chief Marketing and Communications Officer at the Small Business Investor Alliance. As many of you are aware, the SBIA is the Advocacy Association for investment professionals focused on America's lower middle market companies. Our association has maintained a key role in promoting the growth and vitality of this industry and the small businesses it supports for more than 60 years. We're pleased to bring you today our Lunch and Learn webinar series with the topic Managing Credit in a Downturn. Our series of educational webinars is designed to provide valuable content for our members, industry colleagues, and when the topic is relevant, the management teams of investor-backed portfolio companies. A couple of housekeeping items. The presentation slides for this presentation are in the handout section of your GoToWebinar menu bar. And if you have any questions for our speakers, please use the questions feature, which is also located in your menu bar. We will monitor this section and the panelists will address questions throughout the webinar. You can also use this feature to let us know if you're having technical issues, and today's technical director, Michelle Lamel, will reply with suggestions. Please note that this session is off the record. Any comments, statements, and materials are for the express use of SBIA members and are not to be published or recorded without approval by SBIA and the professionals at Foley Hoag. Today's session is possible because of the support of our longtime sponsor, Foley Hoag. Headquartered in Boston, Foley Hoag provides strategic legal services to public, private, and government clients around the world. The firm's long-standing focus on high-growth industries enables its lawyers to offer creative but practical solutions for clients in a range of sectors, including the life sciences, healthcare, technology, energy, and the financial and professional services sectors. To serve companies in these rapidly changing industries, Foley Hoag brings an understanding of its clients' products and services and related intellectual property value, combined with the insight of political and regulatory issues, unique financial aspects, or environmental concerns affecting their businesses. This multidisciplinary approach draws on the support of lawyers who have been scientists, engineers, and researchers, and have held senior level positions in presidential administrations, on Capitol Hill, in regulatory agencies, and with industry trade associations. From offices in Boston, New York, Washington, D.C., and Paris, Foley Hoag's team provides exceptional service to clients ranging from startups to multinational companies. Today, we welcome Allison Bauer, Tom Draper, and Jennifer Audi. And Jennifer, it's now my pleasure to welcome you and your colleagues and turn the virtual podium over to you to introduce your fellow speakers and get the session started.
Great, thank you, Mary Brown, and thank you to SBIA for having us. So for those of you who I don't know, I'm Jen Audi. I'm a partner at Foley Hoag. My practice focuses on SBIC fund formation and licensure, as well as portfolio transactions. Today, I am very fortunate to be joined by two of my partners, Allison Bauer and Tom Draper. Allison is a partner in our bankruptcy and restructuring practice. She focuses on business reorgs, creditor rights, distressed acquisitions, and financing. Tom is a partner and the co-chair of our debt finance practice group. Tom represents borrowers and lenders in a variety of debt transactions, including acquisition financing, ABLs, large syndicated loan, bond offerings, mezzanine loans, and dozens I haven't even mentioned as well. Our presentation today is going to focus on strategies and opportunities for managing credit positions during this very unprecedented time of economic uncertainties. We're going to walk through a few different ways to manage your credits, but I want to start actually by asking Tom to lead us off and walk us through some initial actions that can be taken when a credit appears that it could be in trouble. So Tom, if you could start by talking about what should our borrowers and lenders be thinking about at the first sign of trouble? What are some things that you've been seeing in the market during this period?
Good. Well, we've listed on this slide a number of the different documents or sort of outcomes that could happen short of a bankruptcy. Everybody's familiar with an amendment. If you have a distressed borrower, you need to make changes to the covenants, perhaps the amortization. A forbearance agreement is different from an amendment in that usually there's not a consensual resolution. So the lender agrees not to exercise remedies for a particular period until either you're able to negotiate an amendment or the borrower takes other steps such as selling assets or achieving other milestones that will make the credit situation better. Turnaround consultants we'll get to in a few minutes. But other steps that a lender could consider is assigning the note and the collateral, perhaps to a distressed debt fund. If you're an SBIC, you may not have the overhead to work with a very troubled credit. Would it make more sense just to sell your position? And then kind of the mirror image of that would be, would the borrower be able to sell itself in a consensual transaction? Now, Article 9 UCC sale is a foreclosure. It would require, an event of default, typically an acceleration by the lender, and notice that the lender is exercising its collateral rights. You'd have to post notice, usually at least 10 days in various trade journals to publicize a sale, and you would have an auction. We've actually used this in a consensual manner during the pandemic for a particular borrower. And Allison, you might just note, New York has had a couple of cases that have affected how the UCC foreclosure sale, which always has to be conducted in a commercially reasonable way. But what's happened in New York in a few of these cases?
That's right, Tom. While you mentioned that you recently had one that was consensual, where the foreclosure is not consensual, parties have objected, and since June, we've had at least 2 New York court decisions which have held that the proposed foreclosure sales were not commercially reasonable because of COVID-19. There had been an administrative order by the judges which provided that no auction or sale in any residential commercial foreclosure matter would be scheduled prior to October 15th. And while this order didn't apply to UCC foreclosure actions, the courts have found that logic persuasive and deemed where their value of the LLC interests that were being foreclosed upon was inextricably linked to the value of the underlying real property, and they felt that there's severe turmoil in the real estate market and the ability to receive fair market value was uncertain given the severity and the length of the pandemic. And so they actually enjoined, in this case, the mezzanine lender from proceeding with the foreclosure sale until at least October 15th. Remains to be seen if that gets extended further. But it's clear that both commercial courts and bankruptcy courts are listening to parties' issues with respect to the effects of the pandemic on processes.
Good, thanks. Some other terms that you might have heard: deed in lieu of foreclosure would be a consensual real estate sale where instead of going through kind of an auction and formal process, the borrower would just literally turn over the deed to the property to the lender on a consensual basis. And an assignment for the benefit of creditors is a state liquidation procedure. It's used for some small businesses because it's cheaper than bankruptcy, but it does not give the protection against third-party claims that you would get in a bankruptcy. So a purchaser from an assignment for the benefit of creditors could be subject to claims of other unsecured creditors or creditors that are not party to this transaction. And then obviously litigation to force any of these. Well, the next slide just quickly shows what should be going through a lender's mind when you have a distressed borrower. I think the key is to look at your own documentation first, particularly for problems with your own collateral. If a bankruptcy or even an assignment for the benefit of creditors or foreclosure is on the horizon, you need to make sure that you've got a priority right in all the assets that you expect. So time to run new UCC searches. Have there been any omissions or mistakes? Have there been new subsidiaries for the borrower that you need to file against? Any deposit accounts where you need a control agreement? Any real property that nobody bothered to take when the loan was initially documented, but would make sense now. Any other guarantors or stock pledges that are needed, or filings in the Patent and Trademark Office. You'd want to look at the capital structure. Who are the other creditors that you'll be competing with? Do they share any collateral with you? And if you're senior to them, do you have the right to block payments to those creditors? Or if they try to exercise remedies, can you exercise standstill rights to keep them from acting? Then time to update your appraisals and perhaps get a commercial finance exam to get a good handle on the liquidation value of your collateral. And then decide who's speaking for the lender. Will it be the relationship officer who originated the loan, or will you be substituting a workout team? And then we have the documentation, which we just went over, but one that I would emphasize would be a default or reservation of rights letter. It's critical that you document an event of default and what's happening, even if it's to say that you'll be in forbearance for a period while you negotiate. The worst thing that could happen to a lender is to establish a pattern of waiving defaults by conduct, so that if you don't document these, you don't make any changes, the borrower could later say, well, I had always understood that this was all right with the lender, but now they're trying to exercise remedies and take action against me. You want a good paper trail that sets out exactly what will happen in a finite period as a result of the default. Then the next slide just has some of the things that would be covered in these agreements. An amendment, you might want additional interest or fees because of the increased risk, but at the same time, the borrower is probably in a liquidity problem. So would any increased interest need to be made as payment in kind or PIK? And would you need tighter covenants or different covenants and more collateral? What's the time frame for your forbearance or the milestone dates for borrowers to achieve maybe a sale of assets or to have obtained a new customer relationship? And then in the forbearance agreement, again, you'd maybe revise the payment schedule to postpone principal, but 13-week cash projections instead of just an annual projection. You might want to get these at least quarterly. You might want weekly reporting about liquidity. A turnaround advisor could do diligence on your borrower, make sure that the reporting you're getting is accurate, and see if there's any low-hanging fruit, any operational improvements or management of cash that the borrower could exercise. And then management changes would have to be consensual. There'd be lender liability if the lender put pressure on management to replace a particular individual, but that could be facilitated if it's consensual with the borrower as well. And then a possible sale of the business with an investment banker. And usually any documents would have a release of claims by the borrower against the lender. Well, these have all been sort of general steps that any lender would take with a distressed borrower. And Jennifer's going to talk about some of the particular issues that an SBIC would face.
Thanks, Tom. So that was really helpful. So, we're still in the phase, thinking about before you're getting into bankruptcy proceedings. So if we're doing modifications and so for those of you who are SBICs, these modifications are a good way to extend the runway a little bit for the borrower, but you've just got to keep in mind, if you're doing modifications, you do have to still abide by the cost of money regulations for under the SBIC program. So there are ways where you can include default interest up to 7% additional points on top of the contractual rate of interest if there is a default. But you have to remember, it's not just any default. It has to be a payment default or a failure to provide certain information. So, for example, a financial covenant default is not going to allow you to charge that extra interest within the cost of money exemptions. So just something to keep in the back of your mind as you're doing these modifications, as you may be trying to renegotiate some things, you still got to keep those SBIC regulations working in the background as well. So turning it now over to Allison. So if we get to the point of a bankruptcy, what do we need to be thinking about as lenders and borrowers?
Sure, and let me start by just making sure everyone understands that, the goal of a Chapter 11 case is for the debtor to reorganize pursuant to a plan of reorganization, as compared to a Chapter 7 case where a trustee is appointed to marshal the assets and make distributions to the creditors pursuant to statutorily defined priorities, the absolute priority rule. So our focus here is going to be on Chapter 11 reorganizations. I will note that you can have a liquidating plan as opposed to a plan of reorganization in a Chapter 11, and we are certainly seeing a number of those with respect to the retail industry now, where you have a lot of companies who are going out of business and going out of business sales and ultimately filing a liquidating plan rather than just having a trustee appointed and marshaling the assets that way. It gives the debtor a bit more control over the process. So we like to think that the United States Bankruptcy Code balances the protections of the debtor to provide it with a breathing spell so it can have a fresh start when it's reorganized with the creditor's rights under their contract and applicable law. Upon the commencement of a case, the automatic stay happens, and it prevents the commencement or continuation of any pre-petition legal actions, enforcement of a pre-petition judgment, and any act to take possession of property of the estate. It has to be property of the actual estate. And so this prevents secured creditors from foreclosing on collateral, as Tom had previously discussed, and from pursuing their defaults in that regard once the bankruptcy case is commenced, the stay is in effect. It's in effect immediately upon the filing without any notice and lasts for the duration of the case, which is different than some other foreign jurisdictions. And in fact, if creditors act in violation of the stay, they could be sanctioned and their actions could be deemed void. There are some limitations to the stay, including governmental actions under their police or regulatory authority, such as environmental cleanups, acts to collect post-petition debts. The stay is only with respect to pre-petition, not post-petition debts. And as I mentioned, it's with respect to property of the estate. So if you have actions to collect non-debtor assets, such as letters of credit or non-debtor guarantees, those are not stayed. I'll note that there's also safe harbor provisions for financial contracts where the counterparties can liquidate, terminate, net out commodities contracts, forward contracts, and securities contracts. And we've seen a lot of litigation on the application of the safe harbor in the Tribune and Lyondell and other bankruptcy cases. But again, the automatic stay is a power and a protection of the debtor, and that's really balanced against the secured creditor's right for adequate protection. So a secured creditor has a right, if their collateral is going to decrease in value, they can be adequately protected for the diminution in value of the secured cash collateral, among other things. In a Chapter 11, the debtor's management continues to operate, but its funding is limited by the DIP lenders, the debtor in possession, we call it DIP, the DIP financing controls that are in place in that credit agreement, which really control the spending. There'll be a budget, there'll be a 13-week cash flow, and that's the way for the lenders to have a bit of control over the bankruptcy case. The debtor has the exclusive right to file a proposed plan and can assume or reject contracts, but it has to keep its current post-petition obligations current. So while it can reject or assume leases, until that point in time where they're rejected, it has to pay the post-petition obligations. Now, we've seen a lot of nuances to this during the pandemic. In Modell's, for example, we represented some landlords, and there were many issues there where the debtors did not want to make post-petition payments during the lockdown period, arguing, among other things, that there was frustration of purpose under the contracts. It was impossible because there were government orders preventing them from going in the stores. And ultimately, the landlords and the lenders and the debtors worked out a compromise settlement in that case, but we've seen it in other cases too, where debtors filed and really tried to limit, in the retail industry at least, limit their payment of post-petition rent during the COVID lockdown periods. There's obviously extreme court oversight to the process. There's disclosure requirements and monitoring in the US by the official committee of creditors. There's a creditor body that is appointed. Usually it's the top 7 creditors or so who elect to be part of the committee. The U.S. Trustee's Office, a division of the Department of Justice, determines who can sit on the committee of creditors, but courts give a lot of deference to the committee, and they certainly have a lot of say in the various steps during the case. This is balanced by challenges to the secured debt, lender liability actions that the debtor can take. And so, they may try and alter the priority scheme and alter the ability of the secured lender to realize upon collateral by a number of statutory provisions and common law causes of action, attacking the value of the secured debt. The Unsecured Creditors Committee also gets a period of time to review the secured creditors' lien priority and validity of the liens. We have fraudulent conveyance actions where transfers for less than reasonably equivalent value at the time the debtor was insolvent can be voided. There's equitable subordination, both mandatory and not, where there's some form of inequitable conduct, like lender control over the business, that could cause a claim or interest to be subordinated to other claims or interests. We've also seen issues for recharacterization of debt to equity, where parties seek to have the lender's debt treated as if it was equity. The courts really look to the terms of the document and the terms of the drafting. Does it have a maturity date? Did they provide for interest? Did they act upon defaults? Were there defaults in the documents? All those factors go into whether or not the debt should be recharacterized to equity. And you see this playing out a lot where you have incumbent equity, especially in a situation like the pandemic now, where they want to put more money in, need to put more financing in to get through a rough patch, and will do so as debt. But the question is, are they really trying to treat it as equity as opposed to shareholders' loans that can be have the priority of debt? There's also issues in terms of make-whole payments. Those came into play in the American Airlines bankruptcy case, for example, whether the make-whole payments in the credit documents should be denied or allowed to be paid. And finally, the creditors have the benefit, secured creditors have the benefit of having credit bidding. You can bid for assets, the face amount of the debt at auction, and this really gives huge leverage. It doesn't take into consideration if the debt is bought at a steep discount, unless the court finds that there's some showing that there was a chilling effect on a robust auction, or that it shouldn't really uphold in full the secured creditors' credit bidding rights. But for the most part, what we're seeing now is that the secured lenders are teaming up with strategic parties and credit bidding their assets to operate the entity outside of, once it emerges from bankruptcy. So going on to the next slide, this is sort of a chart of the priority scheme. As I mentioned, the absolute priority rule is where senior classes are paid in full before any distributions are made to junior classes. Generally speaking, secured creditors are paid first from their collateral securing their claims, and the remaining assets are distributed to all unsecured creditors pro rata. Certain creditors do get the benefit of having a grant of super priority status, entitling them to payment before priority claims, and in some cases, even before secured claims. Certain types of unsecured claims are granted priority status, entitling them to payment before other unsecured non-priority claims. And as I mentioned, claims can be subordinated to others as well. This can happen both contractually and in an intercreditor agreement, and we'll talk a little bit more about the effect of intercreditor agreements in bankruptcy, or by equitable subordination or mandatory subordination if there's a claim that relates to the purchase or sale of a security. So if the secured creditor has a claim and the value of the collateral is insufficient to fully satisfy its secured claim, then it's deemed undersecured and receives an unsecured deficiency claim equal to the amount of that differential. And it can waive its unsecured deficiency claim and elect to treat the entire face value of its claim as fully secured. This is known as an 1111B election, and can give the secured creditor a large stake in the class of unsecured claims, perhaps allowing them to affect the plan process a bit. Going on to the next slide. So here we're talking about financing and adequate protection. To use cash, which is secured by a loan, the debtor needs the secured lender's consent or court authorization. But the lender has to be adequately protected, as I mentioned, for any diminution in value of its collateral. And adequate protection is usually in the form of a replacement lien or cash payment of post-petition interest. Most debtors, when they file, don't want to have a court fight on the use of their cash collateral. From day one, they need to get certain orders entered, the ability to pay their employees, the ability to pay utilities, to keep the lights on, and really to signal to the creditors and the rest of the parties that are watching that this can be a feasible Chapter 11 process, and so they really don't want to have a fight with the secured lender on the use of cash collateral. Oftentimes, there's additional borrowing that has to happen in order to pay for all the restructuring costs, to pay for the lawyers and the accountants and all the advisors and the turnaround consultants that Tom mentioned and so forth. So the debtor has to borrow money, and again, this is with bankruptcy court approval, and the post-petition lender often receives protections to encourage it to do business with the debtor entity. In most cases, as I mentioned, require DIP financing in addition to cash on hand. Where there are no unsecured assets, which is typically the case, usually there are blanket liens on all the assets by the existing pre-petition lender. DIP lenders usually get a priming lien. This is a lien either pari passu with or senior to the existing lenders. Again, this has to be done with consent or adequate protection, and often, the reason that you have the incumbent existing lenders providing the DIP financing is because nobody wants to get primed and no one wants to get into a priming fight. So they would rather provide additional financing than have a priming fight with new financing coming in. But we do see situations where, especially where there are multiple parties within either a tranche or within a credit facility, where sometimes you do have fights between the lenders, where one wants to provide financing and not the other. And we're seeing a bit more of that now in a couple of cases, actually. And so the DIP financing, you know, sometimes we say it often can be done offensively as a takeover device where you're doing what we call a loan-to-own strategy, where you provide the financing to get through the restructuring period, credit bid, and then come out owning the assets. As I mentioned, they can be subject to competition between lenders as well. And Jen, I'll turn it over to you now.
Yeah, and so just to pause here for a moment, because we're at the halfway point, I just want to remind everyone, if you want to ask questions, we'll try to answer them as we go, but we're going to try to leave some time at the end too to take questions. But also just so taking what Allison talked about, again, for those of you who are SBICs, you've got to continue to think about the regulatory scheme work in the background. So, you know, if you've got a proceeding, if you're involved in a proceeding as the lender, what do you need to tell SBA about what's going on? So there is a general rule that anytime that you're party to a litigation, you have to notify SBA and keep them posted and let your analysts know. There is an exception for enforcing your rights under your transaction documents, which I think it's pretty safe to say a proceeding would fall into. However, you know, you do want to keep your analyst updated as a best practice, and that's because as you're going through this process, you may need various waivers and consents. If you've got a cost of money issue, if you need to put in additional financing, if you need to do that DIP financing, are you going to, you know, blow your concentration limits and things like that? So what we found is as these things are going on, just let your analyst know. That way, as the case is proceeding, and as the business hopefully emerges in some new structure, they're on board and can, you know, help with whatever consents that you'll need to continue your investment in the business. So just to circle back, one thing we talked about at the beginning, intercreditor agreements. And so I confess I forgot who was going to talk about this one. Allison, okay, Allison, back to you.
Okay, thank you. So as we mentioned, intercreditor agreements define the lien subordination and payment subordination. Those are two distinct rights that are usually expressed within the intercreditor agreement. And, you know, it establishes the rights and remedies amongst the loan parties upon a bankruptcy event. Bankruptcy courts do enforce subordination agreements. You know, and in terms of the drafting, there's typically a provision where the parties acknowledge that it's a subordination agreement under Section 510A of the Bankruptcy Code, which will be effective before, during, and after the commencement of a bankruptcy case. And the typical points that may be negotiated depending on the deal terms and leverage of the creditor parties include who can provide DIP financing. Is it provided up to a capped amount? If the first tranche lender can provide it up to a capped amount, what about if the second tranche, and they don't want to, can the second tranche lender provide it? Is there a capped amount for them? What happens when the borrower wants to use cash collateral? Do the parties, do the other subordinated lenders have the right to object to the use of cash collateral or not? What does the form of adequate protection look like for the use of cash collateral? And what are the rights of the creditors with respect to asset sales? Who can bid? Typically speaking, the senior lender can bid, and if the junior wants to bid on assets, do a credit bid, it has to take out the senior lender or provide enough cash to cover the senior lender. And finally, who gets the vote on a plan? And, you know, we could give a whole lecture on how all these terms are done and utilized. Obviously, they've been negotiated over the years, and so there are some form provisions that parties like to follow, but it really does depend on the leverage of each of the parties. And, you know, as we said, now is the time to dust off your intercreditor agreements and start reviewing them ahead of a bankruptcy filing, especially if you're being asked to do an amendment to loan agreements. Not only should you be looking at what your rights are vis-a-vis the borrower, but what your rights are vis-a-vis the other lenders at this time as well. So going on to the next slide, you know, as I mentioned, there are specific terms relating to DIP financing. Typically, the junior lender can't object to and is deemed to have consented to any use of cash collateral provision of DIP financing by the senior lender. Usually the first lien may only have a seniority relative to a limited debt amount. You know, the junior lender doesn't want to be so far underwater, and so it will try and negotiate upfront a cap on the senior indebtedness. You know, it could be a cushion, a percentage, 10 to 20%. Usually the cap includes the principal amount of the first lien term loan, the lesser of the revolver commitment and any borrowing base, inadvertent over advances, and additional amounts for to cover restructuring costs for the DIP financing. Junior and second lien lenders may not propose DIP financing that primes or comes ahead of the first lien lenders. That's usually in the agreements. Also, junior or second lien lenders may not seek adequate protection unless the senior lenders do so, can't oppose the senior lender's request for adequate protection, and any payments that the juniors receive for adequate protection payments should be paid over to senior lenders in full until they're paid in full. Intercredit agreements also provide that subordinated lenders waive their right to seek relief from the automatic stay or object to the senior lender's request for such relief. Again, you know, relief for the stay would be foreclosing on the collateral, and so the seniors don't want the juniors going ahead and seeking those rights in a court motion with the court. And typically they waive their right to challenge the senior creditor's lien. Again, the debtor and the unsecured creditors could do so, and oftentimes the committee does that because the debtors usually waive that as part of getting the DIP financing. But courts do preserve the fundamental bankruptcy right of a creditor as to object to something as an unsecured creditor. This may be, you know, arguing whether there was commercial reasonableness or not, but there are certain protections that would be available to all unsecured creditors, and courts have upheld that if it's expressly provided for in the documentation. Okay, turning to the next slide, as I mentioned, the intercreditor agreements often provide for the terms during a bankruptcy sale of assets. A bankruptcy sale is commonly known as a Section 363 sale, and typically the intercreditor agreements dictate what happens during the case. The senior lenders are deemed to have consented to any 363 sale of collateral if, the second, I should say, lenders usually agree if the first agrees to it, provided that their liens attached to the proceeds of the sale in the same priority as the liens on the collateral. So if there's a sale of assets and you had a second lien, you would have a second lien on the amount of the sale proceeds. You know, it depends what the actual purchase price for the assets is, if it covers your lien or not. Courts typically look to an express release in the contract drafting in the intercredit agreement if the second lien lenders are going to object or not be able to object to any sale that could be raised, any sale objection that could be raised by an unsecured creditor. Again, I think we talked about credit bidding. The secured creditor can bid its debt in the sale of collateral, and again, you're bidding on the face amount, so this is a huge advantage, and we're seeing a lot of this with respect to cases as of late where the incumbent lenders have significant blocking authority from anyone else bidding on the assets, because you're bidding on the full debt amount and not on the value of the collateral underlying it.
Okay, and just like everything else, if you're an SBIC, there's a regulation for that. So, you know, the acquisition of assets in the full or partial liquidation of a portfolio company is permitted. You know, there's regulations for how it needs to be done. It has to be done within a reasonable period of time. you are allowed to have reasonably necessary expenditures associated with the acquisition. And then you have to remember that if you have outstanding leverage, there are certain circumstances where SBA prior approval is going to be required. So you've got to, again, think about your overline limit. So this is why, going back to what we talked about before, it's always good to just keep your folks at SBA updated on what's going on in case you need to proceed with one of these transactions. And then again, there are certain circumstances where you've also got to consider your existing regulations that would be in place for any other transaction as an SBIC. So, for example, if you're going to dispose of your assets to a capital A associate, perhaps the investment is in Fund 1 and it's done with its investment period, but you've got Fund 2. Then you want to, sell those out or buy those assets into Fund 2. That's an associate. You may need to get prior approval for that. And then you've got to demonstrate that the terms are at least as favorable as an independent transaction. So again, just things to keep in mind as you're going through the process as an SBIC. You've got a couple more hoops to jump through. And then I'll turn it back now again to Allison to just talk about the plan process.
Right. So the next couple of slides will focus on the plan process. The debtor has the exclusive right to file a plan for 120 days, which can be extended for cause to 18 months, and to solicit votes for 180 days, which then can be extended to 20 months. So this gives the debtor control over the plan process, but there's a time frame and a time limit in place. And that time limit also serves to cut the restructuring costs and make sure, cases used to go on for years and years, and the goal is not to have that happen. There's a court-approved disclosure statement. The disclosure statement contains information that's supposed to be adequate to the informed investor, and the court has a hearing on whether or not the disclosures are adequate, and whether the disclosure statement, which sort of describes what's happening in the plan, and the disclosure statement gives a nice overview of the debtor, what its business was, its operations, and the events leading up to the bankruptcy case, as well as what happened during the bankruptcy case. So if you ever want to look at something from a historical perspective, the disclosure statement is a nice place to look at to really get a sense of what had transpired and what happened. And the disclosure statement describes what the treatment under the plan will be. For a plan, similar situated creditors must be classified in the same class. They have to be substantially similar to the other claims or interests. For example, trade creditors would be similarly situated in a class, but may be in a different class than subordinated debt claims, although arguments can be made either way. If a bankruptcy court, one thing we're seeing, I don't know how many of you deal with unitranche debt, but where you have unitranche debt, you have one class. And so there may be limitations on voting for the plan based in the credit agreement, in the unitranche agreement, because they're situated and looked at as one class. And that could really give a blocking position if it's considered one class, to the first lien lenders in that situation. The plan has to be approved by all classes of creditors. Unimpaired classes, those that are getting 100% recovery, do not vote. Usually that's the administrative claims, which they get paid out in full. The impaired classes, those that are receiving some recovery, but not full recovery, for the class to be approved, for the class to approve the plan, you need 2/3 in dollar amount and 1/2 in number of each class voting in favor of the plan. So again, the plan will set forth all the classes of creditors, and parties will submit their ballots, and they will do a tally and add up both the dollar amount of the claims and the actual number of voting participants to determine if they've met these threshold amounts for approval of the plan. If you're not getting any recovery, usually that's the equity claims, can also be higher, equity interest can also be higher claims, then you're completely impaired and deemed to reject the plan. The plan is confirmed if it meets all the statutory factors in Section 1129 of the Bankruptcy Code, which means that it complies with the code, it's proposed in good faith. You have to disclose the reorganized debtors, directors and officers, and their compensation. And if there's an impaired class, at least one non-insider impaired class of claims has approved the plan. And each class either approves the plan, or you can have a cram down plan, which I'll talk about in a minute. The plan also has to be feasible. It has to be realistic that it's going to be able to meet its debt obligations upon emergence. And there's also best interest of creditors test. Each creditor has to be provided with at least as much as it would receive in a Chapter 7 liquidation. So as I mentioned earlier, Chapter 7 liquidation follows the absolute priority rule. And if a creditor would have received more following that rule than the way the plan has structured their payments, then it's not in the best interest of creditors, and the plan should be confirmed under that theory. Going on to the next slide, to cram downs. Section 1129B of the Bankruptcy Code allows for what we call a cram down of the plan over a dissenting class of creditors if certain conditions are met. The plan has to be fair and equitable and not unfairly discriminate. For it to be fair and equitable, they must show that the holders of the claims retain the liens securing their claims and receive deferred cash payments having a present value equal to the value of their collateral, or the sale of the collateral is free and clear of liens, which liens attached to the sale proceeds, but subject to the secured creditor's right to credit bid. And if the plan provides for the realization of the secured creditor's claim by some means, it must provide them with the indubitable equivalent of its claim. I won't go into great detail on what the indubitable equivalent means, but it is a term of art, and there's been many cases on detailing whether, whether they got something from the plan that was equal to what they had going in. In a cram up, I should note actually that there was a recent case dealing with unfair discrimination. This was in the Tribune bankruptcy case just this summer. The Third Circuit issued an opinion where they dealt with enforcement of intercreditor subordination rights, and the junior lender argued that the cram down plan should not have been enforced because it took away their strict enforcement of their subordination rights. And the court really created a new test, a materiality test, and looked at the difference in what they received under the plan as opposed to if there was a strict enforcement of the subordination agreement, and said, yeah, it really wasn't material, and so the plan didn't unfairly discriminate against those subordinated lenders and could be upheld. And that's really, for us was sort of a new light. And I should note, for those of you who don't know, the Third Circuit governs Delaware. A lot of cases are filed in Delaware because that's where companies are incorporated, and that's one of the bases for determining your jurisdiction. So that is of significance when we're dealing with intercreditor rights and what could happen in a plan scenario vis-a-vis the secured and the senior lenders. A cram-up plan is where the secured debt is restructured without the consent of the secured creditor by repaying the debt in full over time, possibly with other modifications to the debt instrument. So this is something that sort of instills a bit of fear in secured creditors. You know, am I going to get out of this bankruptcy case? Am I going to get out of the loan, or are they going to cram up and reinstate the loan and provide me with the indubitable equivalent of my secured claim? You know, am I going to get the same interest rate? Is the interest rate applied to the loan post bankruptcy going to be a market rate, or some other rate of interest? So, you know, occasionally we see those issues going on, and remains to be seen too what parties do with PPP loans. Those are unsecured loans, but you know, and the SBA has to have approval of them. Actually, I'm going to talk, I won't skip ahead because I am going to talk about that in a little bit. So I'll go on to the next slide now, which deals with the Small Business Reorganization Act. So putting aside everything I just said about the plan process, in February of 2020, right before the lockdowns took effect, the Small Business Reorganization Act became effective, and this created a new subchapter 5 of Chapter 11 of the Bankruptcy Code, which is specific to small businesses, and the goal was to make their bankruptcies faster and less expensive. A small business debtor is defined as a Chapter 11 debtor that is engaged in commercial or business activities and has no more than $2.725 million in non-contingent, liquidated, secured, and unsecured debt, not less than 50% of which arose from commercial or business activities of the debtor. The CARES Act increased this debt limit to qualify under the Small Business Reorganization Act from the $2.725 million in debts to $7.5 million of debts, expanding the SBIA's scope. This change only applies to cases filed after the CARES Act became effective and will apply for 1 year before reverting back to its original debt limit, absent an extension of Congress. So until March 27, 2021. And what the SBIA does is provide for a streamlined process. Only the debtor can propose a plan of reorganization, and it does not have to obtain approval of a separate disclosure statement or solicit votes to confirm a plan. There's no unsecured creditors committee, which is appointed. Again, that's a huge cost saving because the unsecured creditors have lawyers, financial accountants, advisors, which get paid out of the estate. A status conference is held within 60 days of the petition date, and the debtor needs to file its plan within 90 days of the petition date. So certainly fast-tracked process. And the protections of the SBIA also grant the debtor a discharge after it completes all payments due within the first 3 years of the plan, or a longer period not to exceed 5 years as the court may fix. The discharge relieves the debtor on all debts provided under the plan, except debts on which the last payment is due after the first 3 years of the plan or such time fixed by the court, or debts otherwise non-dischargeable under the code. Okay, now I think we're going to turn to the treatment of PPP loans, and Jen, I'll let you take it, and I'll chime in as need be.
Yeah, so I think I just want to address this quickly in our last few minutes here. So, you know, I'm going to skip over some of this because, you know, PPP loans are no longer available to obtain anymore. We've sort of passed that point, absent some other legislation that comes out. But there was this issue about whether if you were in bankruptcy, you could take a PPP loan. I think what we're starting to see now is how these loans are going to be treated in bankruptcy, and that's still shaking out. They are unsecured. We've seen a few instances where debtors go into bankruptcy while they still have PPP funds available that haven't been spent yet. So there are, you know, acquirers out there trying to obtain, you know, the assets out of bankruptcy, but also take the PPP funds because that's potentially forgivable cash that they can get in the door. There is this issue you need to be aware of, which is that a change in control must be approved by SBA under its current policy. And failure to obtain that consent from SBA puts the forgiveness of the loan at risk. It also puts the guarantee of the original lender at risk. So no lender is going to sort of consent to this ahead of time. So I think that is still shaking out in terms of how they're treated, you know, through the bankruptcy process, if the funds are going to go with the reorganization. And then Allison, I don't know if you want to briefly just touch on, you know, what you've seen or maybe haven't seen in the process.
Yeah, we're starting to see a couple of cases being kicked around where parties, you know, first what we saw, as you mentioned, was whether or not a debtor could get a PPP loan, and there was a lot of maneuvering around that, and some debtors were enjoining the SBA from prohibiting them from getting it. Others were having their cases dismissed with permission of the court, getting the loan, and then refiling. And I only mention that in case there's an extension without further legislation that would open up PPP loans to debtors in bankruptcy. And now what we're seeing is whether the loans will be carried through the bankruptcy case in effect and be part of, you know, where there's an asset sale pursuant to a plan of reorganization. Will they be able to have this PPP loan carry through, or will they have to pay it as an unsecured claim? You know, a lot of times the purchasers of assets will leave a certain amount for the unsecured creditors on the table, because most of these vendors are going to be their vendors going forward as well, and they want to quell some of the objections by the official committee of unsecured creditors, so they'll leave something on the table for them. So how the PPP loans would be classified remains at issue. You know, arguably you'd want to put them in a separate class if it's going to dwarf the claims of the unsecured trade creditors, and perhaps either cram down on the PPP loan and see if you can do that. You know, there'll have to be arguments made against the SBA's consent rights. So a lot remains to be seen as cases are starting to flush out now on these.
So we're at the end of our official presentation. I'll just remind everyone, we've got a couple minutes, so if there are questions, feel free to put them in the chat. While we're waiting, I want to, you know, we gave Tom a break here for a little bit. So I'm gonna ask Tom my question, which is, you know, Tom, you obviously see a lot of these agreements, lender side, borrower side. What are people asking for since we entered, you know, this situation back in March? What forgiveness are lenders doing? Are they adjusting financial covenants? Are people being reasonable? What are you seeing on the sort of beginning stages of this?
Well, one case that I have now involves an equity cure, and I'm representing a borrower, and the sponsor has the right to cure the financial ratio defaults, but only twice in any 4 quarters. And there's been quite a game being played because they needed to use the equity cure for June. They're trying to squeak by in September without using the cure, and then hope to use it again for December. And it's just raised, you know, a lot of interesting questions. There was one technical default where an interest rate protection was obtained after a deadline, but then it was obtained on favorable terms, and the borrowers challenging the lender like, oh, you know, we believe that default has been cured, so that if we did pay down the revolver in order to meet the September 30 leverage test, that we could reborrow it the next day, and the lender's taking a more formalistic approach. So, you know, that's been maybe the juiciest situation that I have. Typically, if a borrower can provide a business plan that shows a way out, but by when is the question? Say by January or March, the lenders generally have been cooperative, but who knows what that target date will end up being.
Well, we're at our hour here, and I know people have a lot of work to get back to. So I'll just say, if there are other questions as you're looking at the handouts and things come up, please don't hesitate to reach out to any of us. You all have the presentation, which should have our contact info in it, and we're happy to follow up with you on any additional questions that you might have that came out of it. I think I now pass it back to Mary Brown to talk about the next webinar.
Yes, thank you, Jennifer. Tom and Allison, thank you very much for this timely discussion. We appreciate the time and the expertise that you have so graciously shared with us today. A replay of today's webinar, along with the presentation materials, will be distributed to SBIA members and will also be available on the SBIA website at sbia.org, where you can review our previous webinars as well. Our next Lunch and Learn webinar is Tuesday, September 22nd, and will feature a discussion about the impact of COVID-19 on portfolio company valuations. In addition to the SBIA webinar series, we hope that you'll participate in one of our other upcoming fall events. This year, Capital Links is going virtual and is scheduled for the week of October 26th. Virtual Capital Links utilizes the strategic matchmaking platform between institutional investors and lower middle market funds, offering an exceptional networking opportunity both for GPs who are actively fundraising or going to market soon, and for LPs that are looking for new fund managers to invest in. SBIA is also hosting golf networking events around the country. These small group outings are a great way to connect in person in a safe, friendly setting. So please visit our website at sbia.org for details on either of these events. If you are not an SBIA member and would like to learn more about joining our organization, please contact my colleague Alex Frick at 202-628-5055 or email membership@sbia.org. Finally, thank you again for participating in our webinar today, and we look forward to having you join us again next week.